Hi everyone, this is Veronica. Today we are going to talk about right to self-defense because recently Supreme Court has given a certain judgment. We'll see in detail. There we can see an expanded scope of this particular right to self-defense. We'll discuss that in detail. For my video updates, you can follow me on Instagram and Facebook. This is a channel StudyIQ. If you're preparing for any government exam, our pen drive and tablet courses are also available. For additional information, you can call on these numbers or you can visit our website too. The PDF of this lecture will be available on our website. It will be available in both the languages, Hindi and English, and here you can see the number of courses we have in our pen drive and tablet courses. Now see what is the relevance of this topic from exam perspective, from UPSC perspective. It will be covered under polity and at objective level. What is right to self-defense? Subjective level, what is the expanded scope that we can see here, how Supreme Court has interpreted this particular right. Now, why it is in news? Because right to self-defense now, according to Supreme Court, it extends not only to one's own body, but he or she can protect the other person also, other property also. This is what the Supreme Court has interpreted, how they have interpreted the provision of Indian Penal Code. Now see, we'll talk about this particular case in detail first before watching what are the key highlights of the Supreme Court judgment. Just see what is this case. Now it is a case back in 1988, the things happened. In that instant, the appellant is Mr. Sukumaran. While traveling in his jeep, he's a forest ranger with his driver, he saw a gang of 4 persons attempting to smuggle sandalwood from the forest. When he confronted them, they threw stones and attacked him and his driver. So the particular officer, he opened fire in self-defense, which resulted in the death of one of the smugglers. Now, trial court awarded life sentence to this officer, but the court acquitted his driver. So, on appeal, Madras High Court reduced the sentence to 5 years. 5 years imprisonment. Now the present appeal which was heard in Supreme Court was directed against this particular judgment. So allowing the appeal and acquitting him, Supreme Court bench said the appellant was entitled to exercise his right of private defense against the deceased. But here I want to give you the prosecution version also. See, the prosecution version was the Sukumaran shot the Basha was a person who died. He shot that person in the back. So the ranger and his driver were in a jeep in early hours doing the rounds of the forest. When they saw a truck, they gave a chase. The truck stopped and 4 men, including the person who died, got out, and then this ranger took out his gun and fired at the person, killing him. So the ranger then planted a gun in the truck and loaded it with 276 kg of sandalwood to frame the deceased person as a smuggler, the prosecution said. This is what is the version story which prosecution framed. But here the Supreme Court completely disbelieved the prosecution version and rather went with what the forest ranger said. So the later said that this particular prosecution, I'm not talking about the prosecution but the person appellant, he said the companions were first pelted stones at their jeep, following which they pulled out a gun on the ranger, and then the ranger was quickly to draw and shoot the person in self-defense. Now this is the case. I told you both the stories of the prosecution and the appellant. Now see what are the key points of this Supreme Court ruling. Now court has observed that the right of private defense, it extends not only to the defense of one's own body but against the offense affecting the human body, and also to defend the body of any other person. So this is the extended scope of right to self-defense, which we earlier used to think that it just pertains to a single person, single individual. Now this right also embraces the protection of property also, property in the case of robbery, theft, mischief, criminal trespass or anything like that. Now there are 2 more points to be taken care of here. Now the court has explained the right does not arise if there is time to have recourse. That means that if the people should not act in self-defense if they have time to call the public authorities. For example, police. If there is a heated argument going on between 2 people and there is a time to call the police so that the things can settle down in peace, then that is a better option. And nor does it extend to the infliction of more harm than necessary. It does not mean that in self-defense you just have to kill the other person. If there is some other method, one can use that. So it is a case by case study also. Supreme Court has specially said this also because there could be consequences to this judgment also, because now people will get an excuse. If there will be a normal fight also, the person can kill another person and say that I have done this in self-defense, but then there's a case by case study also, and these things to be taken care of. Now when death is caused, the person has exercised the right of self-defense must be under reasonable apprehension. So a reasonable provocation or apprehension should be there as a reason of death of the other person, or there should be a reason of grievous hurt or injury to the person who has exercised the right of self-defense, or to those whom is protecting. The court has said these 4 things. So these 4 lines in PDF you will get them. These are very important. Like as the prelims is approaching, these could be framed in statement wise questions. Now see, the Supreme Court has concluded that there was no reason for the smuggler and his companion to roam in the forest area in the wee hours, and sandalwood was an expensive commodity. So the ranger was only trying to protect his life and that of his driver. He was doing his duty. So besides, 4 of the prosecution witnesses turned hostile, and the testimonies of the rest has no connection to the manner in which the incident has occurred in 1988. Supreme Court has given this judgment. Now see, court has also observed that right of private defense extends not only to defense one's own body, as it is explained here, and this verdict was delivered on 7 March 2019. Now let's talk about right to self-defense. Now sections 96 to 106 of IPC, it deals with right to private defense. And see, it is not necessary that there should be an actual commission of the offense in order to give rise to the right of private defense. Even if a person who faces imminent and reasonable danger of losing his life or limb may in an exercise of self-defense inflict any harm, even extending to death, on his assailant, either when the assault is attempted or directly threatened. So it is enough. It is enough if the accused apprehends that such an offence is contemplated and it is likely to be committed if the right of private defence is not exercised. Now see, especially the sections 97 here, it states that a person has right to defend A is his own body, then B is the property that is movable or immovable of himself or of any other person against any act or theft. And however, the right of this private defense is not an absolute right, that you need to remember, and it is subjected to restrictions that are contained in section 99, and section 99 states that the right is in no case extends to the inflicting of more harm that it is necessary for the purpose of defense, right? So we can say it is an expanded version because this is a unique judgment in its own where the person is acquitted for the right to self-defense. There are more cases also. So in case study, it is important. You should know about right to self-defense and about this judgment also that you can mention, and you can remember this also, section 96 to 106, especially section 97 and section 99 that I have explained to you. So this is all about today's lecture. If you have any query, you can contact me on social media. Thank you.